Magistrate Judge Fitzpatrick just dropped another seismic opinion today, and the shockwaves are already tearing through every corner of the prosecution's case. This isn't a minor procedural note. This is a full-scale legal earthquake aimed squarely at the government's own conduct. The focus once again lands on the filings submitted by Lindsay Halligan and Pam Bondi, two prosecutors whose affidavits now appear to contradict each other in ways that are not small, not accidental, and absolutely impossible for any judge to ignore. One affidavit was used to justify Halligan's appointment. Another was used to deny the defense access to grand jury materials, but Fitzpatrick's new ruling makes one fact undeniable. Both cannot be true at the same time, and whichever one is false may unravel the entire case. At the center of this legal firestorm is a 2-hour gap in the grand jury record. A gap the government has insisted for months is nothing more than deliberations. A gap they claimed contained no missing testimony, no missing evidence, no omissions of any kind. But Fitzpatrick just threw a grenade into that narrative. He writes that Halligan's affidavit cannot be true as written, a phrase that, in judicial language, is as close to "you lied to the court" as it gets. And that leaves the prosecution with only two horrifying possibilities. Either Halligan and Bondi misled Judge Curry, or they misled Fitzpatrick, meaning a sworn statement in one courtroom directly conflicts with a sworn statement in another. Judges do not tolerate contradictions like this, not in low-stakes cases, and certainly not in a politically explosive federal indictment. Fitzpatrick writes that an affidavit filed in one case may destroy the government's credibility in another, and that appears to be happening right now. The opinion goes further, stating that the integrity of the grand jury process itself may have been compromised, not by the defense, but by the prosecution's own handling of evidence, procedures, and sworn statements. This is not a paperwork mistake. This is a foundational collapse. Fitzpatrick also turns his attention to how the government treated James Comey's attorney-client privilege, and the findings are devastating. He identifies systemic mishandling of privileged material, failures in filtering procedures, and improper exposure of protected documents to the grand jury. The judge writes these violations could justify a motion to dismiss the indictment outright, a rare and extraordinary remedy, reserved only for the most severe prosecutorial misconduct. Up until this ruling, only judges had access to the full grand jury record, but that secrecy is now gone. Fitzpatrick orders the entire file, every transcript, every exhibit, every report, turned over to the defense. This changes everything. Defense attorneys now have the opportunity to dissect the record line by line, to identify misconduct, to expose contradictions, and to build a dismissal argument directly from the government's own documents. And that is only the first chapter of this extraordinary opinion. Fitzpatrick's memorandum details mistakes that no experienced prosecutor would make. He describes errors that border on unconstitutional, errors that directly misstate fundamental legal protections. Halligan is accused of giving the grand jury the impression that Comey had to testify to avoid adverse inference, a complete inversion of the Fifth Amendment. A witness is allowed to remain silent, and juries are forbidden to draw negative conclusions from that silence. But according to Fitzpatrick, Halligan flipped that principle upside down, suggesting Comey needed to speak to avoid suspicion. This is prosecutorial misconduct 101, the kind of mistake law students are warned about in their first semester. Fitzpatrick also accuses Halligan of shifting the burden of proof, implying Comey had to disprove the government's case, a violation so severe that appellate courts routinely reverse convictions for far less. The government, not the defendant, bears the burden beyond a reasonable doubt. But Fitzpatrick writes that Halligan's presentation reversed that burden, misleading the grand jury about the most basic structure of criminal law. The opinion is 24 pages of systematic point-by-point dismantling, documenting procedural shortcuts, mishandled evidence, contradictory affidavits, and possible improper leaks of grand jury information. He warns that if the government lied to one judge, it may have lied to another, and that such conduct, if confirmed, could invalidate the entire indictment. But Fitzpatrick doesn't stop at individual mistakes. He points to a broader institutional breakdown within the Department of Justice. Why was Halligan, an inexperienced prosecutor, sent into a high-stakes grand jury presentation without senior supervision? Why did no veteran federal attorney sit second chair? Why was a politically charged case handled like a routine misdemeanor? These questions cut deeper than procedural error. They go to the DOJ's credibility, its judgment, its oversight, its internal coordination. When an affidavit filed in one courtroom collapses the government's story in another, that is not a small mistake. That is structural failure. Now the defense has the most powerful weapon available in any federal case: the full unredacted grand jury record. You can expect multiple motions to dismiss, demands to suppress evidence, hearings on privilege violations, and challenges to the legitimacy of Halligan's appointment before Judge Curry. If Fitzpatrick's findings hold up under scrutiny, the indictment may not survive. This would be a catastrophic loss for the DOJ, not because of politics, but because of the government's own self-inflicted wounds. Judicial oversight exists to keep prosecutions honest, and this case is becoming a textbook example of why that oversight matters. Fitzpatrick's ruling is near case-ending in tone, substantive in detail, and devastating in its consequences. This is far from over. Expect rapid filings, emergency hearings, and intense courtroom battles in the coming weeks. If you follow complex legal news, this is the kind of opinion that will be studied, cited, and debated for years. Before you go, make sure you follow our channel for real legal analysis. Not spin, not talking points. Just the raw facts and the consequences that follow. Stay informed, stay critical, and we'll see you in the next update.